be on our first case from now on.
All right, good morning. This is People versus Jennifer Fifield, file 211569SD. Mr. Hickman is here for the defendant, and this is the date set for a bond violation arraignment. The allegation is a no-show for a PBT on, let's see, that's 5/14. And let's see, there's another no-show on May 11th. And another on May 8th. So those are the allegations. And Mr. Hickman, how do you wish to address that?
Your Honor, Ms. Fifield would acknowledge the violations. She has an can't spit it out. She has an explanation for the violations, and she has taken corrective measures to make sure that it never reoccurs. In that she now has an alcohol tether that will prevent this sort of thing from happening. She's had problems with sleeping through things and inadvertently missing it, and the alcohol tether is going to eliminate that problem.
Okay, well, I did see a note in a file that she had obtained, I thought it was a Scram device, but it's an actual tether, Ms. Fifield,
Yes.
that you put on your ankle?
Yes, sir.
Okay.
Well, the Scram
All
can.
right. Okay. All right. Well, I guess that's taking it to the next level, and it seems that Ms. Fifield is taking it seriously if she's gone to that length. And I'm going to change the bond to require the tether unless and until I hear differently from the defendant if there's a problem with that. So we'll let it go with that. And is there anything else, Mr. Hickman?
No, Your Honor, thank you.
Okay, thank you, Ms. Fifield. We're all set for today. All right, and you can sign off if you like. Okay, good. Let's see. So next up is Dana Miller, and that is file 2115130M. And Mr. Chamberlain is here on behalf of the people. And Ms. Miller, are you hearing me okay?
Yes, I am.
All right, so this is set for a final conference today. Mr. Chamberlain, has there been any agreement reached?
Yes, Your Honor. Ms. Miller will plead to count 1, dismiss count 2. We are only requesting fines and costs for we're also not requesting any action against the dog. And it is a victim crime, so we'd be able to do sentencing today, but I've spoken with her a number of times. She's been sending me documents, good conversations, and that's where we're at, Your Honor.
Okay, Ms. Miller, is that a correct statement of the plea agreement?
Yes, it is.
All right, give me a minute here.
Okay.
Don't see Ms. Miller's case in.
Okay, let me check.
There it is. Okay.
Okay.
No, I do. All right, Mr. Chamberlain, you said this is not a victim crime, or it is, or I didn't catch what you said about that.
I'm sorry, it is a victim crime because it was a dog bite, and so there is a victim.
So, all right, so I need to schedule this out for sentencing to give Bruce Ritchie a chance to make a statement. Is that correct?
That is correct, Your Honor.
Okay. All right. So, Ms. Miller, do you understand that by pleading guilty, you will have a conviction for dog bite, and that's a misdemeanor? It carries a penalty of up to 90 days in jail. You understand all that?
Yes, I do.
Okay. And other than dismissing the count 2 and the prosecutor agreeing to a fines and costs, no action against the dog, have you been offered anything else to get you to plead guilty?
No.
Okay, and I want to explain that the sentence is up to the court, and I do give a lot of deference to what the prosecutor believes is appropriate in the case. I typically do follow their recommendations, but occasionally I have a different opinion about it.
Okay.
And so I want you to go into this understanding that I could have a different opinion. And do you understand all that?
Yes, I do.
Okay. Have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, I have not.
All right, I need to go over your trial rights with you and make sure you understand all those before I'm able to accept a plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt. And you have the right to a jury trial to make that determination. You understand all those rights?
Yes, I do.
You also have the right to have witnesses against you appear at trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand those rights?
Yes, I do.
In addition, you have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way. Do you understand that?
Yes, I do.
Okay, finally, by pleading guilty, you give up the right to appeal that you would have if you went to trial. And any appeal would be by leave, not by right, meaning it would be up to the appeals court whether to hear any appeal of your sentence or conviction. Do you understand that?
Yes, I do.
Okay, so keeping in mind all of those rights that you have, do you wish to waive them all in order to take advantage of the plea bargain?
Yes, I do.
All right, so is it true that uh, on January 17th, you were at a location in Sullivan Township in Leelanau County, and your dog, apparently a black lab named Moose, bit another person, Bruce Ritchie?
Correct.
Okay, what happened exactly?
Moose Moose had gotten out while I was hooking him up. And he took off and he was barking at Mr. Ritchie and with him and his wife walking. And I took off running after my dog. And he lunged at Mr. Ritchie. Mr. Ritchie put his arm up. Moose grabbed his arm, and then Moose took off and ran the other way. He mistook him for another someone else.
Ah, okay. Okay, that seems unusual for a black lab.
We our neighbor, this is the second time that Moose has he's bitten our neighbor in the back, but that neighbor has also been in our home unannounced to us while we were not here. And then he also came into our yard and provoked Moose. And we have had, Moose has just been on edge ever since then. So we've been a lot of,
Moose mistook Mr. Ritchie for the neighbor then, apparently.
correct. Yes, they wear the same coat. In talking to my vet and another trainer, they said it could have been the coat, could have been the hat, or the way he smelled. But we now have a privacy fence that we have. Because of this, we are moving. We're just waiting for our electric to go in at our property. And Moose has an electric fence plus a shot collar, plus he has a muzzle. And he's never outside without us.
All right. Well, I can see why the prosecutor, with all those precautions, has agreed fines and costs probably makes sense here. But I do want to hear from Mr. Ritchie, and he has a right to attend a sentencing hearing. So we are going to set this out for sentencing. Ms. Odom, you want to pick a date?
Yeah, the date for sentencing is June 4th at 9.
Okay, so June 4th at 9 o'clock. And we'll probably be zooming in like this. You'll get instructions in the mail. And let's see. Is there anything else we need to take up at this time, Mr. Chamberlain?
No, thank you.
Okay, in lieu of a pre-sentence report, I'll just get a copy of the police report. So,
Okay.
All right. All right, we're all set then. Thank you.
Yeah.
All right, so the next hearing is at 9:15. That's Mr. Fort, and looks like we got a few minutes.
Okay.
So I'll be in recess.
Okay.
Until then.
You do.
Uh-oh, did we go live? Yes, we did.
I
Thank
did
you.
it.
Way ahead of it.
Barely.
Hello, the court is just waiting on the judge. I'll be with you in just a minute, okay?
Good morning. Do we have Mr. Gibson here? Oh, I'm sorry, Mr. Fort.
Yes, he's with me.
Oh, okay. You ready to go, Sean?
Absolutely.
Oh, okay. Jennifer, ready on Fort. Thank you.
All right, this is People versus Michael Fort, file 211541SD. And Mr. Warden is here on behalf of Mr. Fort, Mr. Chamberlain for the people. This is the date set for a plea. Mr. Warden, has there been a plea offer?
Yes, Your Honor. The plea offer is to operating while visibly impaired, dismissed, intoxicated.
All right, Mr. Chamberlain, is that a correct statement of the plea agreement?
Yes, Your Honor.
All right, and Mr. Ford, is that also your understanding you'd be pleading guilty to a reduced charge of operating while visibly impaired, and the original charge of operating intoxicated would be dismissed?
Yes, Your Honor.
Do you understand that by pleading guilty, you will have a conviction for operate while visibly impaired, and that carries a maximum penalty of up to 93 days in jail?
Yes, I do.
Have you been offered anything else to get you to plead guilty, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
I have not.
Has Mr. Warden answered all your questions to your satisfaction?
He has.
Let's see, I need to go over your trial rights with you, make sure you understand those before I'm able to accept the plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt by the prosecutor, and you have a right to a jury trial to make that determination. Do you understand all those rights?
I do.
In addition, you have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way. Do you understand that?
I do.
You also have a right to have witnesses against you appear at trial, to cross-examine those witnesses, and to present your own evidence and witnesses, and the court would order those witnesses to appear if necessary. Do you understand those rights?
I do.
And finally, by pleading guilty, you give up the right to appeal that you would have if you went to trial, and any appeal would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear your case. Do you understand that?
I do understand.
All right, then, knowing all those rights, is it your desire to waive them all in order to take advantage of the plea offer that's been made?
Yes, it is.
So is it true that on March 13th, you were driving your car on Southwest Bayshore Drive in Elmwood Township in Leelanau County?
Yes.
And is it also true that you had consumed alcohol prior to your contact with the officer and prior to driving?
Yes, Your Honor.
says you had a .09 reading on a data master. Is that consistent with your drinking behavior that day?
Yes, it is.
All right. And would you agree that due to the consumption of alcohol, your ability to operate a motor vehicle was impaired, meaning another driver might have noticed that you weren't driving in a normal manner?
Yes.
Okay. All right, then, to the added count of operating while visibly impaired, how do you plead?
Guilty.
I will accept your plea. I find it's voluntary, accurate, and understanding. The original charge will be dismissed. And let's see, is this a case where there's already been an assessment done, Mr. Warden?
Yes, Your Honor. I did send an assessment to Third Coast Counseling. It diagnoses him with low-risk alcohol use, recommending a brief intervention with his primary therapist, Joanna Pepe, and he's already accomplished that therapy session.
Yes, okay. Well, let me, I don't see the correspondence here in my file. Is this a first offense as far as criminal history goes?
It is. No criminal history, 38 years old. He owns a business here locally. He is appropriate to be sentenced if the court is willing.
I agree.
Okay. I don't have the assessment. Do you see that, Ms. Odom, in the file?
Okay.
Tammy, I copied you in the email yesterday.
Oh, Sean, I forgot about that email. I apologize. Thank you for the reminder.
No problem.
Let's see here. We've got an assessment and character letters, Judge. I'll get these printed right now.
Okay.
I forgot. I'll be right back.
That was a pretty good meeting yesterday. Thanks for having so many people there. It's also nice to see Sean's face.
That's what I got here.
All right, give me just a couple minutes to look over the letter of the
I'm guessing that's the assessment.
assessment.
Is it the psychotherapy intake is the assessment?
Yes, ma'am.
Okay. I'm sorry, Judge. I totally forgot about my email. See if there you go.
All right, so I have had an opportunity to review both the letter from Jeff Strait as well as Lane Plamondon and the psychotherapy report. So go ahead, Mr. Warden. What would you like to say on behalf of your client?
Yes, Your Honor. Dovetailing on our meeting yesterday, I do think that Mr. Fort is one of those people that, with the presumption now of no probation and no jail, deserves that presumption. He's 38 years old. He owns a very successful high-end painting company that serves the Leelanau and Grand Traverse County areas. Lane Plamondon is a local attorney who obviously is effusive in his praise of Mr. Fort. Jeff Strait is a local banker, also fairly well regarded in our community, and also in high regard of Mr. Fort. Skylar, Michael, but he goes by Skylar, is in therapy himself just for regular tune-ups. There's nothing mentally wrong with him. He's simply he's one of those people that pursues holistic health and good health. This is out of character. And while it's out of character, in my world, and I'm not making excuses, but in my world, it's minimal. He was pulled over for speeding, 53 and a 45 on Southwest Bayshore Drive. Blew a 0.95 PBT and a 0.9 BAC. Again, I'm not making excuses. Clearly a drunk driving, clearly shouldn't have been on the road, but certainly not egregious like the file cabinet full of people I have right now that are definitely much more egregious. I know Skylar feels awful about this, and I know he's learned his lesson. And I know just in talking to him, he is contrite and very humbled and embarrassed. So I'd ask the court consider this as a no jail, no probation sentence.
All right, thank you. I would like to hear from you, Mr. Ford. Is there anything you'd like to add before I sentence you?
Only the obvious, Your Honor. This is a very eye-opening experience for me. I'm very embarrassed and remorseful that I'm even here today in the first place.
All right, thank you. Mr. Chamberlain.
Your Honor, I agree this is a no jail. I think just a short term of probation would be appropriate just for the victim's impact panel highway safety. I suggest 3 months, and if he gets it done prior to 3 months and gets it done tomorrow or whatever it takes, then end probation at that time and just do discretionary testing.
All right. This is sentencing on defendant's conviction of, before I start, Mr. Warden, you said that Mr. Fort has completed these therapy sessions, or the therapy session that was recommended in the report.
Yes, Your Honor. The assessment was in early April. I believe it was April 6th, and he's actually been to therapy twice since then.
But the therapy's completed.
Oh, yes, yes.
Okay. All right. Okay, well, again, this is sentencing on defendant's conviction of operating while visibly impaired. The facts are the defendant was pulled over for speeding, had a .09, and apparently was cooperative with police otherwise, and he's appropriately apologetic and remorseful for what happened, and he has already completed the assessment, which indicates that it does not identify a substance use disorder, given that the defendant is 38 years old. He has no prior history of any drug or alcohol related issues. And the BAC was on the low side, although a .09 is actually a lot of alcohol. Some people would look at that and say, well, it's just over the legal limit, but you know, I would guess 4, 5, 6, maybe even more drinks to get up to that. And let's see, if you're coming to the attention of law enforcement, and that's a typical thing to drink that much, I'm sure your kids are noticing it as well. And I don't want to read too much into this. I don't know what goes on. All I know is about this incident, but I'm just saying if that's a common thing for you, you really need to think about what you're doing. But from what I know, the defendant has completed the therapy that was recommended. It's not recommended as far as the victim impact panel. I think that that's a good idea, and I think it's a worthwhile thing to require, and typically that would be recommended by, if this were a Catholic Human Services assessment, they would recommend that, as well as a brief period of abstinence to assure there's not a greater problem that what's been reported by the defendant. But that's not what I have in this psychotherapy report. And I do think that the fact that the defendant has done 2 sessions of counseling, and it's laid out pretty well what issues were addressed in that counseling. I don't see going beyond what's recommended in the substance use assessment. To the defendant's credit, he has the support of a couple folks that took the time to write letters, including Mr. Straight, who describes the defendant as a business leader, a volunteer in the community, a good father and role model, and Mr. Clemondon, who makes similar comments about the defendant. Apparently he owns and operates a business, Fortified Coatings, and does very well at that. So other than this offense, the defendant appears to be an upstanding citizen, and I think this is the sort of case that the legislature was thinking about when they said there should be a presumption of no jail or probation unless there's some reason why the court would go beyond that. So I am going to limit this to fines and costs only. Assume that this has been a wake-up call anyway for the defendant, and we won't see him back again. So the fine is $100. There's $100 cost, $75 crime victims fund fee, $50 judicial system fee, and the $125 arresting agency fee. So that is the sentence of the court, you'll need to contact our court clerk's office to take care of that amount. And is there anything else for either side?
No, Your
Thank you.
All right, thank you. All right, do we have John Gibson present?
Yes, Your Honor.
Okay.
Can you hear
Give
me?
a minute. Yes, I can. Let me rename you here. I've just got the phone number up. All right, we're here on two files involving John Frederick Gibson, file 1523 and 1531. Mr. Razovy is here on the defendant's behalf. And Mr. Razovy, has there been any plea offer made?
Yes, Your Honor. The people have offered Mr. Gibson to plead to an allowing an unlicensed person to operate a motor vehicle. The remaining counts, I believe, would be dismissed.
Okay, Mr. Chamberlain, is that an accurate statement of the plea agreement?
Yes, Your Honor.
All right, and I assume that that's in file 1531 that he's pleading. That's the driving suspended case. I don't know.
No, it's in 21-15-23, Judge. He has two cases. One he's unrepresented in.
Okay.
I don't know what's going on with the other case.
That is correct. It's on file 21-15-23, Your Honor.
Okay. And 1531 is being dismissed.
Sorry, there was actually one more part to the plea offering. I forgot to mention.
What's that, Mr. Chamberlain?
There was also another case that we weren't going to charge regarding driving while license suspended. And I'll just tell you the ticket number. So that's in, and that's ticket 26643.
All right. So,
No idea what this is. Let me see.
can you repeat that last case number, Mr. Chamberlain?
Dismiss file 21-15.
Yes, Your Honor. It's not a case number, it's a ticket number.
Oh, a ticket. Okay.
Yeah, we just didn't charge the driving while license suspended. We were just holding it with this, trying to get it complete. The ticket is 26643.
Mr. Chamberlain, I need to ask you something. So on the plea offer, it says that what Mr. Razovy said, that he's allowed to, well, allow an unlicensed driver to operate. And then you're dismissing case number 21-15-23, which, no.
1531.
Yes, 1531.
You pick your poison, I don't care which one.
No, this status memo is the opposite. I think it's just a mistake.
Well, we've got the prosecutor here, so
Yeah.
I'm not concerned about the memo.
All right, I'm not
So,
gonna look at that then.
And I believe
let's
I'm
see.
appointed on 1523. So if we wanted to enter it, that might be the cleanest way.
That's a good idea.
Right. Okay, so I'm gonna summarize this again, and I'll be asking you, Mr. Gibson, if that's if this is an accurate statement of the plea agreement. So what you're going to be doing is pleading guilty to an added count in file 1523 of allowing an unlicensed person to operate a motor vehicle. The original charges in that case, the no insurance charge and the no or driving on a suspended license charge would be dismissed, as well as the driving suspended charges in file 1531 and the uncharged ticket case 26643. Is that your understanding of the plea offer?
Yes, sir.
Okay, and has anything else been promised to you to get you to plead guilty, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, sir.
Has Mr. Razvi answered all your questions to your satisfaction?
Yes, him and the prosecutor's been helping me a lot.
Okay, good. And let's see, I need to go over your trial rights before I'm able to accept a plea, so please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial to make that determination. Do you understand all those rights?
Yes, sir, I do. Thank you.
You also have the right to have witnesses against you appear at trial, to cross-examine those witnesses and present your own witnesses and evidence, and the court would order those witnesses to appear if necessary. Do you understand those rights?
Yes, sir, I do.
Okay, and in addition, you have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way. Do you understand that right?
Yes, sir, I do.
And finally, by pleading guilty, you give up the right to appeal that you'd have if you went to trial, and any appeal in this case would be by leave, not by right, meaning it would be up to the appeals court whether to even hear any appeal from your conviction or sentence. Do you understand that right?
Yes, I do, sir. Thank you.
Okay, so knowing all those rights, do you wish to waive them all in order to take advantage of the plea bargain?
Yes, I do. Thank you.
Okay, so turning to the complaint, then in this file 1523, it says that on January 26th, you were driving a car on Jacobson Road in Suttons Bay and Leelanau County. In Suttons Bay Township, Leelanau County. Is that true?
Yes, sir, it is.
Okay, and your license was suspended or revoked at the time. Is that correct?
Yes, that's correct.
Okay. Then to the added count of allowing a suspended person to operate, how do you plead?
I plead guilty.
All right, I'll accept your plea. I find it's voluntary, accurate, and understanding. So, what I know about Mr. Gibson is that he's had a lot of problems with his license and has driven and been caught several times, and no insurance as well. What else do I need to know about this case, Mr. Razvi?
Well, I think you're absolutely correct on as far as what you know thus far. He has had a lot of problems with his license, and since I've gotten acquainted with Mr. Gibson in February, I think it's pertinent to point out that this is somebody that this is a complicated process for clearing up his license, part because of the financial obligations and in part because of dealing with other courts and administrations and things of that nature. Since February, Mr. Gibson has paid off numerous tickets trying to clear his record. With the assistance of the prosecutor, he and I were able to decipher a complicated driving record, get this issue kind of narrowed down to an administrative issue out of the state of Indiana. Apparently, there are significant child support arrearages out of Indiana that is making this more complicated than a traditional just pay off this ticket and off you go. In large part, that difficulty happened because Mr. Gibson was incarcerated and arrearages never stopped. He was still being treated as if he was out, incurring his support obligations and then penalties and arrearages on top of that. Mr. Gibson believed he had submitted the proper paperwork to get that cleared up and was on a payment plan. So he was driving, believing the Indiana issue had been cleared and that he simply had to pay these tickets, which he did. And since February, he did go to the Secretary of State under the belief that he had cleared everything up and learned that in fact he had not. As of this morning, following the prosecutor and my conversation, we've given him the contact info and everything that we've been able to figure out of Indiana's FOC. And Mr. Gibson has assured me that he is going to make every effort to get that taken care of, as this is the last piece of the puzzle that I can see that needs to be rectified so he can get a license. It's a tricky thing because there are significant arrearages. He obviously needs to pay those up. He wants to pay those up, but he needs to work to do that. And of course, he has been pulled over multiple times, either to or from work. He knows he can't continue to do that because this was a very, very favorable resolution, one that is not likely to be offered again. So he does understand that he's on thin ice as far as getting in pulled over again or driving again. But to his credit, he is making efforts. I would also add that his wife is making efforts. They've been in contact with me. They really do want to clear this up, Your Honor. And I guess I would just ask that you consider consider fines and costs at a nominal level if you could, because Mr. Gibson has already paid a lot of money just recently. And candidly, more money is going out than coming in at this time.
All right. So, Mr. Chamberlain, anything you'd like to say?
Yes, Your Honor. This has been, the driving history has been, as Jason said, difficult to decipher. Only yesterday, we found out that he was still suspended, even though, according to all the information we had, he'd fixed everything. And then a 1996 case popped up for a friend of the court, and he wasn't, and when he went to register his vehicle, they then suspended him on that day and gave him like just a weird suspension for something that was 25 years old that he didn't know about, because it just occurred. So this has been, I've been working with Jason, I've been working with Mr. Gibson. I agree with Jason that nominal fines and costs are appropriate, so that way he can get this other stuff taken care of, because it's tens of thousands for this whole case in 96. And I don't know how much of that is arrearages and fines and things of that, but it's, we've got the contact, and yeah, that's where I'm at. Thanks.
All right, Mr. Gibson, I would like to hear from you. Is there anything you'd like to add?
Yes, Judge. I'm sorry about driving. Only times I've been stopped is coming back and forth from work. I'd even be happy with a restricted license because I don't do anything else but work. With the rears, with the child support, I talked to a detective and paid him to be able to get the bench warrant and my license back reinstated. Now that happened back in March. And then they told me to pay $50 a month to be able to have my license and not have a bench warrant. And that's what I've been doing. So when I recently found out about my license, it was through Lansing because of me being stopped so many times. So they asked me to write them a letter. I wrote them a letter, and I've just asked them to give me a restricted license so I can at least be able to hold my job, so I can pay my mandatory child support and be able to take care of my family.
Where are you working at?
This company called Multi-Shores Development. It's over off Hickner Road by it's North Grand Traverse School, I think, or West Grand Traverse School. But it's a little development area that's been built, and I've been over here building houses for these people.
What sort of work is it?
It's doing framing, house framing, construction.
Okay. Are you working full time pretty much?
Yes, sir, I am.
Okay. It says in the originally you were homeless. Are you still homeless at this time?
No, I live in Sutton's Bay, 2187, Nishnah Bay, Sutton's Bay, Michigan, with my in-laws.
All right. Okay, well, this is sentencing on defendant's conviction of allowing a unlicensed driver to operate a motor vehicle. The reality is the defendant was driving himself, and he doesn't have a license, still doesn't have a license, and he also did not have insurance on the car, had a plate that, interestingly enough, it says he created the plate himself, so I'm wondering how good of a job you did there. But anyhow, the prosecutor and defense counsel have obviously spent a lot of time looking at this case and working with the defendant. And it's been stated that the defendant has been only operating the vehicle to go back and forth from work, which I'm not giving you some kind of clearance here today, and the prosecutor certainly isn't either. You get stopped again and you're suspended still, you're going to get another ticket here. So that's my biggest concern here, is that the prosecutor's given you a generous plea bargain here, but you have got to buckle down and get your license fixed, or this is just going to go on, and it is very hard to support a family and all the other obligations when you can't drive a car. But you know, you're going to have to depend on someone for rides to get to work anyhow until then, because you get popped again, the next prosecutor might not be so generous. But I'm going to go along with what the parties are recommending, because they have, I think, put a lot of thought into this. And so I will keep the fines and costs rather low. It's going to be $100 fine, $100 cost, 75 crime victim, 50 judicial system fee. You can work out a payment plan with the court to get that paid off over time, but make sure you contact them to set up that payment plan, or else what happens is, if they don't get any money, they put out a bench warrant for you, and you don't want that to happen. So I'm going to give you the clerk's phone number here. Have you got a pen to write it down?
Yes, sir, I do.
Okay, so here it is, 231-256-8250.
Okay, thank you, Judge.
All right, so make sure you call that number and get a payment plan set up so that they don't think you just blew it off anyhow. So, well, good luck getting your license back. Thank you, Mr. Asby and Mr. Chamberlain. Okay, we'll go on to our next hearing, and that is People
Thank you,
versus
Judge.
Timothy Mikovits. Yep, thank you. Feel free to sign off at this time if you like. So,
Thank
Mr.
you, Attorney.
Mikovits is here, and let's see, is it Miss Ascione here on behalf of Mr. Mikovits?
Yes, Your Honor.
File 21, okay, file 211527 SD, Mr. Chamberlain, and Mr. Donaldson now here for the people. Let's see, this is set for a bond hearing this morning, and
Mr. Pedersen on.
Actually, Miss Ascione is filling in for Mr. Pedersen this morning.
All right. Nice
So,
to meet you over Zoom.
Nice to meet you as well. Thank you.
All right, so I have a report here of some violations, and that's the Smart Start report. Have you had an opportunity to review that with your client, Ms. Ascione, and what's your position on this bond violation?
I have had a chance to review with Mr. Mikovits. Our position is that he was not using the machine correctly. There were two. At first, he was given a machine on the first day on April 7th. And once he got home, he realized he was not able to blow into it appropriately. He then went back to Auto Outfitters the next day, was given a second older machine through Smart Start, and it was determined he didn't have the lung capacity for the first one to blow in appropriately. All of the missed tests, it was, so with the second machine, the older machine, he was only able to upload once a week. He had to go in versus every night being an automatic upload for those tests. So once he realized he had missed all the tests for the first week and part of the second week, it was a bond violation. He realized he was not using it appropriately. He's since talked to Smart Start. I've talked to his bond officer, and I've also talked to Smart Start myself, and he simply was not had knowledge of using the machine correctly, and he since has been aware of how to use it. The reports from Smart Start, which I believe Your Honor just referenced, show that they were skipped, but also that they were attempted, which just shows that he was not waiting for the green light, is what I'm understanding.
Okay, we've got Ms. Casties here, and our bond officer. And Ms. Castis, I want to verify the last violation that I see is on April 15th. The defendant's on twice a day testing. And so is it accurate to say that there have been no misses or violations or positive tests since April 15th?
All right, yes, Judge, I do not see any positive tests since then. However, we did receive additional reports today, which I've uploaded to OnBase, where there are skip tests. Let me just double check here. April 22nd, April 26th, April 29th through the 6th of May, he was compliant, was able to do the testing. Then between the 6th of May and the 13th of May, we have 4 skip tests, 1 in the evening, 1 in the morning, evening, and then another 1 in the morning. So May 7th, May 9th, May 11th, and May 13th. So apparently he must still be having issues with his machine because they all seem to be the same types of errors. And the information we do have from Smart Start today is they indicated that he has not reached out to their office to report any testing issues, but that they were going to have their technician contact him to go over the testing. Because it appears that he is attempting to test once and receives user did not complete messages, but then does not continue to test until he receives the completed test message.
All right. Now, did you forward that new information to defendant's attorney? It doesn't look like Ms. Ascione was aware of this, and so, yeah,
No,
go ahead.
we did not. We just received this and I just barely got it logged in before you called the case. So I will go ahead and send
Okay.
that to her.
All right. Thank you.
Yes.
Mr. Donaldson, what is the people's response?
Your Honor, I as well as Ms. Ascione have just been made aware of the information, as the court knows. I would tend to credit the information that she's been provided, but I certainly would give Ms. Ascione an opportunity to examine it more carefully if that's something she needs to do, and whether that entails a adjournment of this bond hearing and the prospective plea. I'd leave to the court's discretion. Certainly she could talk with her client in a breakout room as well.
All right. Well, I think rather than put Ms. Ascione on the spot here to try to figure out what's going on today, I would rather give her an opportunity to take a closer look. But I'm just going to say that this would be very unusual that there are this many problems and it isn't a deliberate attempt to skip tests. And so I'm very suspicious of what's going on, and I would be unlikely to buy that Mr. Mikovits just simply doesn't know how to use the device. I mean, he's had he's had numerous days where he's had no problem testing, and then there are all these skip tests even after the last one that Ms. Ascione was aware of on April 26th. And so the idea that these are being skipped and the defendant isn't notifying the company or someone about seeing that the tests are being recorded as skipped or missed, it doesn't make any sense to me. But the other thing that will adjourning this will do is give Mr. Mikovits an opportunity to show that he can successfully complete the testing requirements here. So let's pick another date for a hearing, Ms. Odom.
How about June 4th at 9:45?
Okay, June 4th at 9:45. Is that going to work for you, Ms. Ascione?
Yes, that would be fine, Your Honor. Thank you.
Likewise.
Okay, so, all right. Well, thank you. And we'll leave bond alone at this time then, and we'll be back on the 4th. And so if the defendant doesn't, if I find that the defendant is purposely not complying with bond, he should know I wouldn't hesitate to cancel bond. So that's it.
Thank you, Your Honor.
Thank you, Judge.
All right, let's go on to People versus Cassandra Bermudez, I'm sorry. And is Ms. Bermudez here? Not seeing Ms. Bermudez. She is unrepresented, and this is a bond hearing. And so we'll give her some more time to show up. And then we've got, Ms. Castiche, yes.
Yes, Judge, I believe Ms. Bermudez was sentenced in Ottawa County and went to inpatient treatment there. I haven't received confirmation other than her prospective probation officer did contact our court, and that was their intent. So I believe she is probably an inpatient in Ottawa County.
Okay. So I think probably the best thing to do at this point is schedule this for both a status conference and a bond hearing, say in 30 days. And we'll see if she's out of treatment by that time. That way the prosecutor will have an opportunity to discuss the case with her since she's unrepresented, and we can take up the bond hearing at that time. Does that sound okay to you, Mr. Donaldson?
Yes, Your Honor.
Okay. All right. So we'll wait for our show cause hearings then at 10:15.
Okay. Jesus. Okay. What time is it? 5 minutes.
I'm just gonna go back in. Excuse me.
Jojo Siwa.
Are you Mr. Bonilla Mejia? Hello, is Mr. Bonilla Mejia there? Brian?
Mama, you gotta be quiet.
Sir, who are you on the iPhone?
Flores Morales.
Oh, okay. All right, you're here for a show cause?
Yes, ma'am.
And is there an Askia Seals here? All right. All right, Mr. Morales, we'll get started here pretty soon.
Okay.
Ma'am, what is your name?
Good morning. Mine?
Number 2050. Who are you?
Mine? I'm sorry.
That's okay.
Yeah, I'm the plaintiff for, I'm the attorney for plaintiff on 205061 GC2.
Well, I'm sorry, you faded out, and I don't have that case number on my docket. That's why I'm confused.
Oh, for Munson versus Franz?
I have a 205061 GC, a Munson Medical Center.
That's
And it
the
says
one.
Okay, so. Okay.
Did I write the case number wrong? I apologize.
No, it's okay. It's just 2050 is what you have on there. That's fine. All right, we'll get started. You're here a little bit early, but we'll get started in a bit.
Thank you. I think it just cut off my entire, everything I wrote. It just got cut off when I entered.
Oh, I see what you're saying.
I guess it only allows so many characters.
That's okay. That's all right. I got you. Yeah, that's funny.
Thank you.
All right. You're welcome. Thank you. The only person that's shown for these show causes is Mr. Morales, if you want to take care of that one. Oh. Sir, on the iPhone, what is your name?
Aiden Morales.
Oh, it's
Adan Flores Morales.
Oh, it's you still. I'm sorry, Mr. Morales. You look different.
No, same guy.
I thought you were somebody else. Sorry. Okay, I just let the judge know that you're ready to go.
Okay.
Thank you.
Thank you.
Mhm.
Do you have the show cause reports? Because I can't locate them anymore.
I don't have anything printed. Let me look and see what's in here. So these are like failing to appear for stats and pre-trials kind of a thing. Let me look up Mr. Morales. All right. So defendant failed to show/call for the status conference on May 7th. So because of that, they show caused him. Because he's improper and he's supposed to call in.
What was the date?
May 7th, Judge. For a status conference.
All right, so I'm going to call People versus Aiden Morales, file 173179T. And Mr. Morales, you've been summoned to court this morning because you failed to appear for a hearing on May 7th. And let's see, first of all, you have a right to a hearing and to an attorney to represent you in the show cause hearing. Most people offer an explanation for why they didn't appear, but what do you want to do?
Honestly, it's my fault that I didn't do it because the letter I got in the mail, I didn't read it all the way, and I never seen that the show cause hearing was on the 7th. I only seen the 21st, which was today, because it had 2 dates on it. So that's where I got confused at. I didn't read the letter all the way. I just read the date today at 10:30, and then I just tucked it away.
Okay, well, if you get a similar letter in the mail in the future, you're going to read it more carefully, right?
Correct.
Okay, because today it's a show cause, but the next step would be to issue a bench warrant if you failed to appear, and you could be arrested at work or in your home. And I'm sure you don't want that to happen over this, what looks like a pretty minor offense. But if you don't respond, that's what happens. So, so I have your assurance you're going to show up in the future, right?
Correct. Yes, I will. I mean, I've been trying to get this taken care of for a while now. And like I said,
All right.
I see it.
Well, fortunately, we have the prosecutor on the line right now. I don't know if Mr. Chamberlain, do you have a moment to speak with Mr. Morales and about the case?
Yes, sir.
He's unrepresented. Okay, so I'm going to put you in a breakout room with the prosecutor, and we'll conduct the status conference that way. Okay, you'll need to accept an invitation. It's going to pop up on your phone in a second here. Okay, Mr. Morales? All right. Do we have Andrew Miller here this morning? Andrew Miller. Okay. Mr. Miller's case is 211529ST. It was noticed for 10:15 this morning, and he's failed to appear on this show cause, so we'll go ahead and issue a bench warrant. It's now 10:28 a.m.
How much bond?
We'll set a $200 bond. All right. We also had a show cause this morning on Brian Antonio Bonilla Mejia. Is Mr. Bonilla Mejia present? Doesn't look like it. So case was also noticed for 10:15. It's now nearly 10:30, and the defendant has failed to appear, so we'll go ahead and issue a bench warrant in that case with a $200 bond. All right. Next is Community Housing Associates. And let's see, we've got Mr. Gann here on behalf of the plaintiff, and Mr. Campbell is here on behalf of the defendant. And
good morning.
Good
morning,
morning. Good morning. Has there been any resolution in this case?
If I may, we were very close. We had to wait for several months for rural development to tell us what they'd be willing to do. That has been relayed back to us. I have sent a proposed conditional dismissal to Mr. Campbell, and he is going to do a little bit of tweaking of that. I think we should be able to get this into the court without having to have another hearing on it. We're so close. We just need to fine tune the language on it to resolve this matter.
Okay. You agree, Mr. Campbell, if we adjourn this out, say 30 days to give you time to complete the agreement, that should be enough time?
I think it should be, Your Honor. And if there are any administrative glitches, we can inform the court and get a new date. But I think that would be a good plan.
Okay. All right. Well, I do appreciate the parties working together on this. I know it's we've had several hearings, and but as long as things are moving ahead, and that's what the parties wish to do, we'll go ahead and adjourn out another 30 days. And did you want to pick a day for that?
I can let you know what the 30-day approximate date would be. Let's see. Hang on here. Well, 18 is just short of 30. Otherwise, we go to the second. Let me see if the second's a holiday. It doesn't look like it. The 2nd of July.
Okay, so probably the 2nd of July, and we'll send a notice in the mail. And again, I appreciate your time and effort on this, Mr. Gann and Mr. Campbell. We're all set for today. Feel free to sign off at this time.
Thank you, Your Honor. It's always a pleasure working with Ms. Campbell. And Steve is a very efficient guy too. Ask him what time he woke up this morning. I slept until 5:45.
Oh, that's sleeping in, huh? Okay. Well, thank you both. Have a good weekend.
Thank you.
All right. Let's see. Next up is Munson Medical Center versus Renner. And let's see. Who do we have on behalf of Munson Medical Center?
Morning, Your Honor. Naljat Francis on behalf of Plaintiff's Attorney of Record. And it's the defendant is Jason Franz. The Attorney of Record is Attorney Renner.
Oh, I'm so sorry about that. I misspoke. So, Mr. Franz, is that you?
That is.
I see some initials on it. Okay. Good morning. All right, and this is a motion to set aside a default judgment. Let's see. Has there been any discussion between you? Let's see, Ms. Francis and the defendant about this, or are you ready to go ahead to arguments?
I'd be fine with speaking to Mr. Franz. The court would allow us to go into a breakout room.
All right. Well, so Mr. Franz, Ms. Francis would like to discuss the matter with you in a breakout room, and there's nothing to be lost there. You can listen to what she has to say, and if you don't like it, we'll come back and have a hearing. But let's see. Mr. Chamberlain is back. I'm going to close that breakout room. I'll create a new one with the parties.
Yeah, do you have $20 like this? I ain't got no cash. No.
I just had one of those stuff at their bank because they charge me like $4.
I know. But if you go to Dollar General, they'll charge $1.
Okay, so who do I have at the phone number 616-410-3897?
That's me, Askia Seals.
Sorry, I didn't catch the name.
Askia Seals.
Oh, he finally shut up. Askia Seals, coming from the magistrate for a plea.
Askia Seals.
Yeah.
How do you spell that?
Askia is ASKIA. Seals, SEALS.
Okay.
And I'll see if I can't find that.
All right, we'll be with you in a minute, Mr. Seals. Mr. Chamberlain, have you had an opportunity to speak with Mr. Morales, and has there been any resolution of the case?
There's no resolution yet, but there's been really good progress. He's paid off $1,000 out of about $1,400 in fines and reinstatement fees. He says that he'll be able to have that by in 3 or 4 weeks. I would just like to set this for a final conference on July 2nd, 6 weeks from today. That should give him ample time to fix the suspensions and also to get the license reinstated, so everything's good. The offer is if he fixes his license to the civil infraction that he was arrested for, which is defective equipment, or not arrested for, but ticketed for.
Okay, so Mr. Morales, you agree with that, adjourning this out for the final conference in July? And if you get that paid off, the prosecutor is going to offer a civil infraction. Do you want to go along with the adjournment at this time then?
Correct.
Okay, so that's what we'll do. We'll be back on, let's make sure we get a date and time for that, if you can, Ms. Odom, or do
It was
it.
July 2nd.
It's July 2nd.
Yeah.
And what time?
I didn't pick a time, but we could do, let me look on the docket here. Oh, we can do any time. Let's do 10.
Okay, it'll be at 10 a.m. You'll be zooming in most likely the same way, but look at your notice very carefully because we may be in person by that time. So it'll either give you Zoom instructions or it'll tell you to be here in person, okay? Mr. Morales?
Excuse me, Your Honor.
Yeah.
My phone call dropped and you were asking about my phone number.
Oh, yeah, Mr. Seals, we'll be with you in just a minute. So, but I can hear you fine now. So we'll get back with you in just a minute, okay? So, Mr. Morales, did you hear what I said about the date and time for the hearing?
July 2nd at 10 a.m.
Yep. And just check your notice for whether you're going to be zooming in like today or appearing in person, okay? We're all set for today. Feel free to sign off at this time.
Thank you. Have a blessed day.
Mr. Morales?
Yep, thank you.
Yeah.
Make sure to contact me well before that date so I can run driving history, okay?
Awesome.
Thanks.
Thank you. Hey, is it? Okay, yeah, thank you.
Okay, let's see. Mr. Seals is here from the magistrate's office. Is this a probation violation?
I'm looking at, now it's a bench warrant arraignment that she did, so.
Oh,
Failed to appear for a final conference. Back in October of 2020. And then we set it for 11/2. On 11-4 jury selection, well, that went off the docket anyway. Actually, we had a final conference on 11-2 and he failed to appear for that as well.
Okay, so I'm going to call the case of People versus Eskia Seals 191573 SM1. Mr. Seals, are you able to hear me okay still?
Yes, Your Honor.
Okay, so you've been, you're here this morning because you failed to appear for a final conference back on November 2nd. And do you have some explanation for why you failed to appear?
I've never received any paperwork or like email or any notice on it. That's just straight and direct to the point.
So how about, my guess is that you maybe changed addresses and that's why we haven't been able to get in touch with you. So what is your current address?
5215 Burgess, Burgis Avenue, Southeast, Grand Rapids, Michigan.
How about a zip?
You know the zip code there?
49508.
Okay, and what's a good phone number for you? Oh, it's up on the screen. 616 410. Yep.
3897. Yes, sir. Yes, Your Honor.
Okay.
38 what, Judge? I can't see.
3897.
Thank you.
Okay, so were you living at a different address back around November, October 2020?
Yes.
Okay, so
Yes.
now we know what the problem is. So I'll recall the bench warrant, and you'll be sure to make sure you show up for any hearings in the future on this case if we send mail to that address, correct?
Yes, Your Honor, definitely.
Okay.
So, Your Honor, would you like me to set it? I think we have a May 25th final conference coming up. Would you like me to get him on that? That's on a Tuesday of next week.
Well, I guess,
Oh,
would it make sense to have Mr. Chamberlain speak with the defendant at this time regarding the final conference?
this is TC case.
Oh, I'm sorry. This is a Grand Traverse case. Okay.
Yeah.
So we're going to set your final conference for next week, is it?
There's one set for next Tuesday, the 25th. Mr. Johnson is
Okay.
his attorney.
So we're going to add you to our docket for next Tuesday because we've already got final conferences scheduled for that time. Mr. Johnson, your attorney's already scheduled to be there. And what time would he need to appear?
We'll do 1:15.
1:15. You're going to log in the same way you are today through Zoom. It's the same meeting ID number.
Okay, so I should, okay, I'll keep all the paperwork.
Okay, good. And you will get another notice at your new address. But yeah, it'd be good for you to just keep that paperwork and call in at that time. And it would also make sense for you to contact Mr. Johnson in advance because he may have another plea offer for you that he needs to discuss with you. And so, Ms. Odom, do you have a phone number for Mr. Johnson that?
I can Google it. Let's see.
Ms. Odom's going to give you Mr. Johnson's phone number here in a second, in case you don't have that handy.
No, I do not. Thank you so much.
Okay.
Okay, are you ready?
Yes.
231-883-6705.
Thank you so much.
Mm-hmm.
All right, we're all set then for today. Mr. Seals, feel free to sign off at this time, okay?
Thank you, Your Honor. Have a great day.
You too. All right, we're still waiting for the general civil case to come out of the breakout room. I had another civil matter, Donald Thayer.
Let me see. I don't have any of that. I didn't
NOP.
even have the other Munson, so I got kind of confused.
Oh, Ms. Castis, I don't know if you're aware of what's going on with Donald Thayer. It says Mr. Hubble's representing the plaintiff, I believe.
And that's a
Or
civil
maybe it's
case.
yeah, it was scheduled for 10:30. What's that?
I'll check with Cindy. She's
Okay.
not on the phone, but I'll check with her real quick.
Oh, okay, thank you. And there's also a show cause on Alfaro at 11, but it's not 11. Okay. And then there's the final conference with Cavazos, 11:05, and then we have show causes on Featherly and Holtcamp. Mr. Chamberlain, is that correct? It's a show cause on the Featherly case. That's not a formal hearing. It's a show cause. And
I don't even know who this Featherly person is. I don't have anything on my docket.
okay, then that tells me that it's not a formal hearing anyway. So
The only thing I
Oh, I'm
have,
sorry, what did I miss here? You know what? Do you want my docket? I feel like you have a really old docket, and I apologize.
okay.
Sorry about that.
oh, I do see a
Yeah,
Featherly,
Miss.
sorry, at 11:30.
Yeah, Miss. Yeah. Looks like it's just a show cause on that, but. All right, Ms.
Excuse me,
Castis, did you find anything out about
Yes.
Thayer?
Yes, on fire, one of the attorneys had a conflict in circuit court, so there was a stipend order signed to adjourn that to the 18th of June. So that case is off the calendar.
Okay. All right, great. Thank you. And Mr. Chamberlain, yeah, on Featherly, I think it's just he failed to appear or something like that. So.
I also see, yeah, at the same
Okay.
time for the same thing.
Ms. Castis, was Bradley Gay the prelim that was stipped to?
Yes, we did
right.
finally receive the signed stip, so Gay has been adjourned.
Okay.
All right. Okay, well, just let me know when the parties are back on the Munson case. Thank you.
Did you click the leave meeting button?
I know. Oh, no, I was trying to get value audio.
Oh, no, sorry. I wasn't talking to you, sir.
Okay, sorry, ma'am.
Mr. Travis and Mr. Gay.
Yes.
Hi, we actually signed the stipulation to adjourn, and I apologize that you didn't receive it in time.
No, that's okay. I had heard that was probably going to happen, but didn't want to, just assume.
Okay, well,
Thank
you're
you.
good to go. You're welcome.
All right. Thank you.
Yep, have a good weekend.
You too.
Okay, we're ready to go on the Franz matter?
Yes, ma'am.
Okay, great. Is it Franz or Franz?
You're muted.
Franz.
Okay, thank you. Okay, we're ready on Franz, Judge. So is there a resolution today, or will there be a hearing on this?
We have a resolution.
Okay.
All right, we're back on the record in Munson Medical Center versus Jason Franz. And let's see, again, this is the defendant's motion to set aside a default judgment. And Ms. Francis, have you reached any type of resolution with the defendant?
Yes, Your Honor, we have. Defendant is agreeing to withdraw his motion at this time, and parties will enter an installment payment order for $50 a month beginning June 20th and by the 20th of each month thereafter.
Okay, is that a correct statement of the agreement, Mr. Franz?
Yes.
Okay. So I do, let's see, are you going to submit that under the 21-day rule then, Ms. Francis?
Yes, we can submit that, Your Honor.
Okay, so you're going to receive a copy of the order, and if there are no objections, it'll simply be signed by the court. But if you have any concerns about the form of the order, just let the court know by email or otherwise, and we'll set it for a hearing, okay? And you have 21 days to do that. All right, well, I'm glad the parties were able to work this out, and so we're all set unless there's anything else for you, Mr. Franz?
I think I'm all set. Thank you, Your Honor.
All right, or Ms. Francis, anything else?
No, Your Honor, thank you.
All right, thank you. Okay, I've got Mr. Nicholas Cavazos, who cannot hear us. He held up a sign a moment ago. And so I'm going to try to figure out what's going on. Mr. Cavazos, can you hear anything? No. So let's see, I'm going to send him a chat message. What should I say?
What it shows.
There we go. Now I could hear.
Oh, there we go.
Ah.
There.
Sorry
Okay.
about that.
All right, no problem. Mr.
Everybody was
Cavazos, I just didn't.
conversating me. I apologize. I couldn't hear nobody.
Okay, I just didn't
figure this thing out.
Didn't quite know what to do to help you, so sorry. So this is set for a final conference today. File 201439ST, People versus Nicholas Cavazos. And so, Mr. Chamberlain, have you had an opportunity to speak with Mr. Cavazos?
No, the last time I attempted to call him, the phone wasn't working that I had, and the email was full. Mr. Cavazos has been working on getting his license fixed. Mr. Cavazos, where are you with that?
I'm at that point to where I didn't know that the situation of going to, well, the fact that the thing that I got put on from a long time ago from the ticket that I was served from Kalkaska or something for running a red or stop sign or whatever, I wasn't aware of that at the time, so I did not know anything about it. And I guess at the time when I went to go try to go apply for my permit, they told me that I had to take care of the ticket out there, that I have an outstanding ticket in Kalkaska. So when I made attempts to go try to do that, they said that I have to pay that first before I had to push forward to do anything.
Right, so have you paid the ticket?
How I paid the ticket, I didn't have no money at the time to pay the ticket at all, so I didn't get a chance to pay the ticket. I was going to take it out of my per cap that's coming this month.
Okay, Mr. Cavazos, before we go on here, I think what I'm going to do is I want to put you and Mr. Chamberlain in a breakout room because I may be overhearing more than I really should. And so you're going to get an invitation on your screen to join a breakout room. And you'll have an opportunity to speak with Mr. Chamberlain about this, see if he's it sounds like he's made an offer to you and whether he's willing to keep that open at this time. So here you go. Look for the invitation. Make sure you accept that.
Okay. No problem, Your Honor.
Yep. Yeah, I had this Daniel Alfaro on my list also.
Yeah,
For show
Alfaro.
cause, that's not going either.
Oh, it should, unless he didn't show.
Oh, he just didn't show.
Maybe. So 2014-35. Let me see what it's for. Just failed to contact the prosecutor for his status conference.
Okay. All right, I'm going to go ahead and call that case. It's file 201435ST and People versus Daniel Cullen Alfaro. And it's now 11:07 a.m. The case was scheduled for 11 o'clock this morning. And if Mr. Alfaro shows up before we're finished with our docket this morning, I won't enter a bench warrant, but I am going to go ahead and request a bench warrant be issued with a bond amount of $200.
So all I have is Featherly, Holt Camp, and this Cavazos.
So on, let's see, Holt Camp, it says
I think Holt. Let me look at the document.
failed to comply with an order. Oh, I've got the information on these two.
Okay. Yeah, those are the collections show cause cases that failed to appear for, I don't know, I guess,
Yeah, collection show cause.
yeah, I guess they failed to appear for that.
And Featherly's the same, then
Yeah.
collection show cause. Okay. We will see if they show up today. All right, I see Mr. Chamberlain is back, as is Mr. Cavazos. And so, Mr. Chamberlain, where are we at?
Your Honor, at this time, there's no offer.
Okay, so let's see, what would be the next step then in this case? I guess we'd be going to trial then, is that correct?
Yes, Your Honor, if that's what he chooses to do. I didn't, I don't know what
Okay. So, Mr. Cavazos, the prosecutor apparently isn't offering you anything. Do you wish to proceed to trial?
I'm not sure exactly what that is because I'm slow and I never graduated, so I'm not sure exactly what I'll be doing. If I said yes or if I said no.
Okay, so let me explain a little bit here. So if you go to trial, we would have a jury selection on one day, and then we would have a trial on the another day. And so you'd show up and you'd pick a jury. Now you can also have a bench trial. That's a trial just in front of me. I would make the decision whether or not you're guilty or not. But you'd have an opportunity to present evidence. The prosecutor would present their evidence. You don't have to present any evidence at all. It's the prosecutor's burden of proof to prove beyond a reasonable doubt that you're guilty. And either a jury or I would make that finding on a separate day. And with the jury trial, you're talking about a jury pick as well as the probably at least 3 or 4 hours for a jury's trial. And then with the bench trial, we'd probably set it for a 1 hour, maybe hour and a half trial to present proofs. That goes a lot quicker. So you have the choice there, whether you want to go to trial, or you also have the opportunity to plead guilty if that's what you want to do. But that's entirely up to you.
Probably trial.
Okay.
So we can probably have more. That's going towards like as in further more discussion as the next time, right?
Well, typically once we pick the jury, there's no more discussions with the prosecutor as far as a plea offer. Okay. So it doesn't sound like there's any further discussions along that line. So do you prefer a jury trial or a bench trial?
What's the difference between those both?
Okay, again, if you want a jury trial, the case would be decided by 6 jurors, and we pick those people on one day, and then we hold a trial on another day. You would need to be present to help pick the jury and the one day, and then they would come back a separate day and we would have a trial. So the prosecutor would present his witnesses and evidence, and you'd have a chance to cross-examine, and then you would present your evidence and give closing arguments, and the jury would make a decision whether you're guilty or not. If you want a bench trial, that's just in front of, that means the judge makes the decision. So I would be making the decision whether you're guilty or not guilty. And there's no need for a jury selection, obviously. So we would just schedule this for a 2-hour trial, and we could probably wrap it up well within that time. And again, you would present your proofs, the prosecutor presents their proofs, the prosecutor has the burden of proof. So that's the difference.
Okay.
You know, so what's that?
Okay, I heard you, Your Honor. I apologize. My microphone cut out.
So
probably bench.
Okay, so we'll set this for a 2-hour bench trial. And you want to pick a date for that, Ms. Odom?
Sure.
So my court recorder, Ms. Odom, is going to pick a date here. Do you have any witnesses that you intend to call, Mr. Cavazos?
Yes, Your Honor.
Okay. If for some reason that witness isn't available on the trial date, you need to let us know right away so we can reschedule. Okay, it's got to be a good reason though, like a death in the family, or they have a pre-planned vacation, they're going to be out of town or something like that. So it'd have to be something substantial.
How about June 18th at 1:30?
Okay, June 18th.
I'm
at
gone.
1:30. Yeah,
in
Mr.
Alabama.
Chamberlain.
I'm in Alabama for training on computer forensics.
Okay. So Mr. Chamberlain is unavailable. Well, we get Mr. Hubble to do it, can't we?
We can. And you know what? We can do that. It's fine.
Okay. Yeah, we'll give Mr. Chamberlain a break, and we'll keep it on the 18th. So it'll probably be a different prosecutor that's trying the case here. So June 18th at 1:30. And I think we'll be zooming in just like today, Mr. Cavazos. So you'll get a notice in the mail. Let me make sure I've got your correct address. Are you still at 2633 North Beams? Beamsquam Mamikon. Oh, you say it much better. Okay, thank you. In Sutton's Bay. Okay, so good. And we'll see you back on that date, but you need to be prepared for trial. So make sure that you're ready to do that, okay?
Yes, Your Honor.
All right, well, thank you, and we're all set for today, okay?
All righty.
Thanks, Your Honor. Have a good day.
Thanks, Your Honor.
All
Have a
right,
good
thank
day.
you. Yeah, thank you. Okay, we've got 2 more hearings at 11:30, and I'll be in recess until that time.
11:30. I was issuing bench warrants already. Review 21. Oh, okay.